The Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989. This act was enacted to address the atrocities against scheduled castes and scheduled tribes, who represent one of the most marginalized and impoverished groups in Indian society. Given their historically weak position, this act was legislated to both guarantee and foster the constitutional promise of non-discrimination against these communities and to criminalize any practices of prejudice and discrimination against them. Despite having gained independence from the British, Indian society was deeply divided on religious and caste lines. The discrimination against people belonging to scheduled tribes and scheduled castes took place in many degrees, from the use of abusive language and untouchability to physical violence and rape, which in many cases led to death. The Prevention of Atrocities Act was announced given the concern over the rise of such atrocities. Objectives: the Act sought to address the rise in atrocities against the SC/ST community and severely punish the perpetrators. The aim was to ensure holistic integration of these communities that have been historically marginalized and subjected to continuous discrimination since the beginning of the caste system. The Act has a total of 23 sections divided into 5 chapters. Chapter 1 is preliminary, which consists of section 1 and 2, which are provisions for the extent of the Act and definitions it concerns itself with. Under section 2C, scheduled castes and scheduled tribes are defined as those castes and tribes which have been assigned the same status by Articles 366, Clause 24 and 366, Clause 25 of the Constitution. Chapter 2, Offences of Atrocities. Section 3 under this chapter outlines the punishment for offences of atrocities. There are 15 atrocities outlined in the Act, but these are not exhaustive, since even other offences could fall under the ambit of this Act. These atrocities include forcing SC/ST members to drink or eat inedible or obnoxious substances, forcefully removing their clothes or parading them naked, forcefully occupying their property, forcing them to perform begar or bonded labor, intimidating them into voting for certain candidates, lodging false complaints against them, humiliating them on the basis of their caste, denying them the right of way, that is, freedom to move across public land, etc. It is evident that the Act covers a wide range of actions and atrocities based on the historical abuse and discrimination faced by the SC/ST community. Section 3 lays down the punishment for these offences. For every category of offense listed under the section, there is a corresponding punishment, depending on the degree of the offense and the effect it has in perpetrating crimes against the SC/ST community. Punishments range from death penalties to imprisonment and fines. Section 4 holds public servants liable for neglecting their duties under this Act with imprisonment of up to 1 year. Under Section 5, if a person is convicted for an offence under this Act more than once, his imprisonment can be extended beyond the actual period of imprisonment by a year. Section 9 states that the state government has the power to enforce this Act. So Chapter 3 deals with the externment. This chapter concerns the removal of persons who are likely to commit offences in a particular area. This can be viewed as a preventive measure. There must be a proper recording of the circumstances under which such a suspicion arose and recording of the measures taken to remove such persons. Chapter 4 provides for establishment of special courts. The Act provides for the establishment of special courts to ensure speedy trial of cases that arise under this Act. It allows for a special public prosecutor to be appointed if such a special court is instituted. Chapter 5, which deals with miscellaneous provisions. This chapter deals with other provisions under the Act which help with its effective functioning. This includes the power of the state government to impose collective fines if it finds atrocities being committed against SC/STs, to take preventive action to maintain law and order in places where atrocities are committed, and the power to override other acts. An important section under this chapter is section 18, which states that the provisions of section 438 of the Criminal Procedure Code, which deals with granting anticipatory bail, will not apply for offences under this Act. The denial of anticipatory bail exhibits the gravity of offences under this Act and the government's intent to tackle these crimes in the harshest manner possible. The Act was amended in 2015 and 2018. The 2015 Act put in provisions to increase the efficiency of enforcing the Act. The Amendment Act in 2018 sought to nullify the effects of the judgment of the Supreme Court, March 2018, which had diluted the provisions of the Act. The Scheduled Caste and Scheduled Tribes Prevention of Atrocity Act 1989 has been widely criticized for its rampant misuse. Complaints were filed mostly against public servants and judicial officers to satisfy vested interests. 2015 NCRB data shows 75% of cases under the Act resulted in withdrawals and acquittals. The importance and impact of this Act. The atrocities against SC/STs have been a major concern for successive governments. The idea that SC/STs do not belong to the mainstream is a deeply ingrained prejudice in Indian society. To maintain the marginalization, there is frequent violence against these communities. While the Constitution of India guarantees non-discrimination as a fundamental right, it is not so in practice. The SC/ST Prevention of Atrocities Act was implemented to specifically deal with this issue. This is a landmark legislation with high penalties for the perpetuation of caste and tribe discrimination. It was enacted due to rising discrimination and continues to remain extremely relevant even today. In March 2018, the Supreme Court banned automatic arrests and registration of criminal cases under the SC/ST Prevention of Atrocities Act 1989. Before arresting a public servant under the Act, a preliminary probe by an officer not below the rank of deputy superintendent is a must, the court had said. The court had also removed the restrictions on granting anticipatory bail. However, Supreme Court later revised its own judgment and came up with a review order. The review order observed that the March 2018 guidelines encroached upon the field reserved for Parliament and therefore recalled these directions. Meanwhile, Parliament came up with a new amendment in 2018 to keep stringent provisions of the Act intact. A new section 18A laid down that there was no requirement for a preliminary inquiry before filing an FIR. This amendment was challenged in the Apex Court. The Supreme Court upheld the constitutionality of Section 18A, which denied anticipatory bail to persons accused of committing atrocities against the SC/ST community. However, the Supreme Court mentioned that high courts would have an inherent power to grant anticipatory bail in cases in which prima facie, an offence under the Anti-Atrocities law is not made out. Besides, a high court in exceptional cases could also quash cases to prevent the misuse of the Anti-Atrocities law. Nevertheless, the courts should take care to use this power to grant anticipatory bail only sparingly and in very exceptional cases. It should not become a norm lest it leads to miscarriage of justice and abuse of process of law.